The final address of Tinubu and Shettima's legal team to the Presidential Election Petition Tribunal is so laughable that it leads one to question whether senior lawyers were involved in the writing of this statement. In some cases, they sound as if they are throwing outright insults to the petitioners. In some cases, you can feel the hubris oozing from the writers of this statement. Anyway, let's take it one by one. In their last attempt to convince the judges that the election was conducted in compliance to the electoral law, they cited many sections of the electoral law just trying to reinforce their argument that the IREV and electronic transmission is of no importance. They claimed that the petitioners had no problem with other procedures like voter accreditation, voting, etc. Only, as they put it in quote, it is not the petitioner's case that there was no electronic transmission and upload at all, but that same was not done immediately, unquote. They claim that the petitioners didn't submit any evidence that proves that the results collated at the Ward Collation Center were different from what was delivered to the Ward Collation Center from polling units. In trying to make their point, they added this line, quote, an aggregation of these clearly shows that it is either the petitioners have, with all respect, naively overestimated the electronically transmitted results, or they have simply decided to throw tantrums as a result of their frustration at the polls, unquote. Comment, what is giving them confidence? This doesn't sound professional at all. They quoted the INEC manual, paragraph 3, which explains the steps to follow for ward collation. The paragraph they quoted is captured in INEC regulations and guidelines, which says, an election result shall only be collated if the collation officer ascertains that the number of accredited voters agrees with the number recorded in the beavers and votes scored by political parties on the result sheet is correct and agrees with the result electronically transmitted or transferred directly from the polling unit as prescribed in these regulations and guidelines. B says if a collation or returning officer determines that a result from a lower level of collation is not correct, he or she shall use the result electronically transmitted or transferred directly from that lower level to collect and announce the result. They also quoted Section 50, subsection 2 of the Electoral Act to support their argument. It says, subject to Section 63 of this Act, voting at the election and transmission of results under this Act shall be in accordance with the procedure determined by the Commission. Yes, that procedure is covered in these INEC regulations and guidelines. Also in Section 60, subsection 5, it says, the presiding officer shall transfer the results, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. Like in Section 50, the procedure is covered in the INEC regulations and guidelines, so they are trying to play down the importance of IREV as regards collation of results, or even the mandatory requirement that forms EC8A must be uploaded after vote counting at the polling unit. It's not the position of the law. IREV is just a name, which can change in the future. The fact that it is not written there doesn't make any difference. If the name changes tomorrow, what will the lawmakers do to amend the law just to change the name? The law doesn't need to capture the name, so they can't choose the one to obey and the one not to obey. If they are arguing that the electoral law allows the commission to determine how to collect the results or transfer the results, and before the election, INEC told the world how they will conduct the election, even by their own guidelines, they explained how they did the training to the polling officers, how they will conduct the election and transmit the copies to IREV on election day. After the election, they now turn around and abandon everything and expect Nigerians to accept it. That's not how it works. On the likely reason they didn't seriously defend the non-compliance that the petitioners alleged, they quoted one judicial precedent, Julius Ocha versus Martin Elechi, 2012. In that judgment, the appeal court said, where a petitioner complains of non-compliance with the provisions of the Electoral Act 2010, he has a duty to prove it polling unit by polling unit, word by word, and the standard required is proof on the balance of probabilities and not on minimal proof. He must show figures that the adverse party was credited with as a result of the non-compliance. Comment. Without quoting everything they said in their final address, the petitioners already showed proof with numbers in their petition. They quoted exact numbers that were wrongfully credited to Tinubu in some states like Rivers and Benue, and they also quoted the number of votes that they scored in the said polling units. The proof of all these are contained in the INEC certified true copies that they tendered in court. Now, let's see their final address on the witnesses, starting with the Amazon witness who tendered evidence from Amazon Web Services. They said, quote, "Documents are totally worthless, being not only inadmissible but no evidential value whatsoever," unquote. They said this because of the ID that the witness tendered in court, which isn't signed. And if you remember when the witness was questioned about it, she answered that the ID of Amazon staff comes without signature, which is not surprising. There are many companies like that. And if they truly questioned her links with Amazon, why didn't they write to Amazon to find out, like Atiku's witness did concerning Tinubu's certificate from Chicago State University? They also claimed that the AWS health report the witness submitted didn't have an author, that the court should disregard the evidence. Comment: the witness clearly stated that the AWS health report is available online as published by Amazon. It's just like when you download Form EC8A from IREV. Who is the author in this case? Amazon is the author. The same way they publish the AWS health report in the 6 regions they operate in around the world is the same way all the forms that polling officers and INEC staff uploaded to IREV are published by INEC. On the subpoena she brought to court, they argued that it was not delivered to Amazon but to her, and that she accepted that she did not come to court on the authority of AWS. So based on this, they said that her evidence shouldn't be taken as coming from AWS. Comment: Amazon is the author of her evidence. They release periodic health status reports of their web services. It's obvious they are just looking for technicalities. Why didn't they verify the authenticity of the report from Amazon, the same way they claim to have contacted Chicago State University? They also have a problem with the letter of confirmation of employment the witness tendered. They said the witness manufactured the letter by herself because of the date on the letter, which is 19th June 2023, a day before she came to court. Comment: what sort of argument is this? Any letter of confirmation of employment written by an employer to an employee must bear the date it was written. So because she's coming to the tribunal, they should backdate it? Many witnesses came to court and made corrections to their statements, so the witness might have demanded for the letter on the said date. So they're just arguing they haven't proved that the witness is not an employee of Amazon. If they wanted to prove this, they would have verified from Amazon within 24 hours they were served the witness statement before cross-examining her. That way they will tender the rebuttal from Amazon. Besides, the Labour Party legal team will never contemplate a witness that is not what she claims. That will be playing into the hands of the defendants, and it will obviously damage their case. In summary, from their statements so far, they don't take it seriously at all. They want the court to believe them and throw away her evidence without any proof. They didn't tender any evidence to prove all the claims they made, so it can best be described as hearsay. Now to the professor of mathematics. They said that he made a comparison of uploads to the IREV and the ones declared by INEC, that the witness admitted that he concluded his assignment on 19th March 2023 before the LP filed the petition, that his work was supposed to come with the petition not forming part of a subpoena at the middle of the hearing, that some of the polling units in his report were not pleaded in the petition. So they went on to cite Section 83, subsection 3 of the Evidence Act, that the entire evidence is irrelevant to the petition. They also quoted judicial precedents INEC versus Abubakar 2009 and Apoti versus INEC 2022. Comment: once again they are looking for technicalities. They couldn't counter the report of the mathematician with any document during cross-examination or during their defense. INEC that conducted the election couldn't even tender all the documents containing results they collated to announce a winner. Now they are just saying that his report should have come with the petition. So they are not questioning the efficacy of the prof or the authenticity of his report. They are only questioning the timing. Of course, the authenticity is not in doubt because the witness said he used IREV copies. So as you can see, Tinubu and Shetima are banking on technicalities with their watery defense. On the testimony of the cybersecurity expert, they showed these lines of code being extract from his statement. They said he should have decrypted it so that the court will understand them in plain language. They even cited a judicial precedent, Ogidi vs. State, 2005, where the Supreme Court ruled that the lingua franca of the court is English language, that the court will not be addressed in another language other than English language, not even through undecrypted codes or metadata. So based on this, they claim that since his testimony are mainly codes and web links, that it wasn't intended for the court to understand it. They cited other inconsistencies in his statement, saying that the evidence is inconsequential, that the court should not consider it. Comment: the cybersecurity expert is a professional that gave his testimony based on his expertise. Granted that he presented lines of code and web links, he still explained what happened in plain English. The reason he submitted lines of code was to back up the claims in his statement. Another major technicality push in their final address is the claim that the petitioners are challenging the results in states where they won and states where APC, PDP, and NMPP won, that they are under ground 2 of the petition, which means they are challenging the election of the second respondent based on the fact that it was invalid by reason of corrupt practices and non-compliance with the Electoral Act. That according to Section 134, subsection 1b of the Electoral Act, that it doesn't envisage a situation where a petitioner will complain about results of the election in places where the overall winner did not win, that the respondents are not expected to defend the outcome of the elections in places where they did not win. They cited the Electoral Act paragraph 49 of the first schedule, which allows the petitioner to join 2 or more candidates as respondents. Comment: the most important thing is that INEC is a respondent. INEC conducted the election, they did the collation, so they should explain why polling unit results, whether hard copy or IREF copies, do not tally with the results they announced. In fact, Tinubu's legal team are supposed to concentrate on defending his qualification issues and Shetima's double nomination. They don't need to be looking for technicalities to prove that the petition is incompetent and not admissible without other candidates being joined. As far as it concerns the election, INEC should be able to defend the votes they credited to Tinubu, which of course the petitioners have said that those votes were not lawful votes, and they have tendered INEC CTCs of polling units. When tabulated, some of these results are not equal to the collated results at the ward level. The petitioners also tendered the forms used in collating the results at the ward level, local government area, state, and even Abuja, so it's easy to detect the unlawful votes credited to Tinubu, despite their trying hard in this address, saying the petitioners have not tendered any evidence to prove their case. So it's not clear what other evidence they want. Now let's see where they expose their limited understanding. Lawyers are supposed to master English language, and even if they don't, they should be able to make use of a dictionary. No one knows the meaning of all words, even native English speakers in England. In their attempt to prove that Peter Obi will not benefit from one of the reliefs he's seeking because he didn't meet the condition, they erred in their submission because they don't understand the meaning of majority. This is an everyday word, but they don't know the actual meaning. We've done a video about this before, but let's summarize what they did. They cited Section 134, subsection 3 of the 1999 Constitution. This section explains the condition to be met by candidates in a runoff election. Going by the official results and assuming that the court will uphold 25% requirement in Abuja, there will most likely be a runoff election. And this section explains the conditions that the second candidate will meet in order to join the first in a runoff election. It says the second candidate must score a majority of votes in the highest number of states. They erroneously said that it's Atiku that met the condition because he scored majority of votes in 19 states. But that's not the meaning of majority. Majority means plurality, which simply means more than 50% of the total. So if there are 1 million total votes cast in a state and one candidate scored more than 500,000 votes, that candidate scored the majority of votes in the state. And in this case, Peter Obi scored majority in more states than Atiku. More details in the video. So expect Labour Party legal team to refute most of their claims in this address. Just like in their reply to the petition before the hearing started, they didn't take it seriously, just like this one. Imagine lawyers not knowing the meaning of majority and they want to stand in front of a judge to argue this. Anyway, the issue of 25%, Tinubu's baggages, and Shetima's double nomination as contained in their final address will be covered in another video because of time constraints. Thanks for watching.